So the FTC has announced a rule banning non-competes. Figured that might be worth going over, considering that has national implications. It might have worldwide implications. Non-compete agreements are controversial under the law because you're supposed to have sideways mobility in a capitalist system, in a free economy. Free but regulated economy, because capitalism is a fire that will run away without regulation. But in a free economy, you should have sideways mobility. You should be able to switch jobs. Workers should be able to choose the better employer. The employers should compete for the best workers. The thing where healthcare is tied to your job, where you can't switch to a similar job because you have a non-compete clause, where you can't sue your employer because you signed an arbitration clause. These things are suspicious under the law. Oh, then salaried workers. And you need to be a salaried worker even though you're not actually managing people under you and need to be like on call as like the manager of the business. No, you're a salaried worker because it's just more convenient to pay you a fixed fee and then pretend that you're available 65 hours a week and all hours of the night for being on call with no additional compensation. So the FTC is trying to push back against some of that. In this case, it's the non-compete clauses. The FTC's final rule, they say, will generate over 8,500 new businesses each year, will raise worker wages because there'll be competition, will lower healthcare costs because there'll be competition, and boost innovation. Today, the FTC issued a final rule, we'll look at it in a second, to promote competition by banning non-competes nationwide, protecting the fundamental freedom of workers to change jobs, increasing innovation, and fostering new business formation. What do you need to know? Not just what they claim. They have a date here that's an effective date. What is the effective date? The effective date is 120 days after publication. So I'm guessing this is publication, or it will be published in the Federal Register, which is a special publication. So the date that is published in the Federal Register, which is on a monthly basis, so at most 120 days after 30 days for publication. So, what is it? The purpose of this rulemaking is to address conduct that harms fair competition. Concern about non-competes dates back centuries, and the evidence of harms has increased substantially in recent years. However, the existing case-by-case and state-by-state approaches to non-competes have proven insufficient, so the federal government is stepping in. Insufficient to address the tendency of non-competes to harm competitive conditions in labor, product, and service markets. I happen to agree, but this is going to be one of those complaints that the federal government is taking over as things that were previously left for the states to decide for themselves. You could have 50 microcosms of disparate treatment of workers, but no more non-competes. The ability of employers to enforce non-competes has always been restricted based on public policy concerns. So courts have limited this. It's been left to the courts to limit this unless the legislatures limit this. And that's all state-based. In Mitchell v. Reynolds, an English case that provided the foundation for American common law, the court noted that workers were vulnerable to exploitation through non-competes and that non-competes threatened a worker's ability to practice a trade and earn a living. These concerns persist. Today, non-competes between employers and workers are generally subject to greater scrutiny under state common law than other employment terms because they are often the product of unequal bargaining power, and because the employee is likely to give scant attention to the hardship he may later suffer through his loss of livelihood. You need the job now, so you'll sign the thing so you can get the job now, not thinking about the job you'll need to get later and won't be able to get later when you want to leave this company. So it's a way to prevent competition. Further, as contracts in restraint of trade, non-competes have always been subject to the nation's antitrust laws. As early as 1911, the formative antitrust case of United States versus American Tobacco, the Supreme Court held that several tobacco companies violated the Sherman Act because of the constantly recurring use of non-competes, among other practices. Like I said, the salaried thing, too. I was subject to that at one of my jobs. I was salaried even though I didn't have any salary responsibilities, but it meant that they could pay me a fixed wage and squeeze a little bit more out of me. Oh, you need to stay late today. You need to get this done. Oh, show us the initiative and we'll give you that promotion. But then the promotion never came. Alongside this large body of empirical work, news reports revealed that employers subject even middle-income and low-wage workers to non-competes on a widespread basis. Workers came forward to recount how, by blocking them from taking a better job or starting their own business and subjecting them to threats and litigation from their employers, non-competes derailed their careers, destroyed their finances, and upended their lives. Yet, despite the mounting evidence confirming these harms and the efforts of many states to ban them, non-competes remain prevalent in the U.S. economy. Based on the available evidence, the Commission estimates there are 1 in 5, or 30 American workers subject to non-compete agreements. Employers frequently use non-competes even when they are unenforceable. This suggests that employers may believe workers are unaware of their legal rights. Well, you are now aware of your legal rights. Employers may be seeking to take advantage of workers' lack of knowledge of their rights or their inability to enforce their rights through case-by-case litigation. Please tell me they included a table of... Why did they not include a table of contents? You are sinners. You are sinners in the eyes of the law. No table of contents for a 570-page document. Are you kidding me? Okay, here we go. Finally, it's at the end. It's at page 561. It's only 9 pages long. Amazing. We just spent 561 pages. I skipped all of it. Talking about what we're about to see here. Let's take a look. Antitrust. For the reasons set forth above, the Federal Trade Commission adds a new subchapter J, Part 910, to Chapter I in Title 16 of the Code of Federal Regulations. That's how you do it. You're literally like inserting some language into the law, like pushing some changes to your GitHub. Definitions: business entity, employment. A term or condition of employment that prohibits a worker or penalizes a worker or functioning to prevent a worker from seeking or accepting different work, etc., 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 is a non-compete clause. Officer is president, vice president, secretary, treasurer, principal financial officer, comptroller, etc. And senior executives who are in policy-making positions. Total annual compensation above $151,164, which I'm assuming will be adjusted year by year. It is an unfair method of competition for a person to enter into a non-compete clause, enforce a non-compete clause, or represent that a worker is subject to non-compete clauses. So now you can't even say, yes, we do have one, and we just disagree with the Federal Trade Commission. For workers other than senior executives. So it is now an unfair method of competition for a senior executive to enter into a new non-compete clause. You can only enforce a non-compete clause entered into before the effective date of this rule, and you cannot hold out or represent that a senior executive is subject to such a clause if the clause came into effect after the effective date. So the only clauses that apply to senior executives are existing ones entered into before the effective date. That's how I read that so far. You must have a notice requirement for each existing non-compete clause that is an unfair method of competition. The person who entered into the non-compete clause with the worker, so the employer, must provide clear and conspicuous notice to the worker by the effective date of the rule that the worker's non-compete clause will not be and cannot legally be enforced. So here it is. A new rule enforced by the Federal Trade Commission makes it unlawful for us to enforce a non-compete clause. As of this date that they're choosing, we will not enforce any non-compete clause. That means you may seek or accept a job with another company or person, even if they compete with us. You may run your own business, even if it competes with us. You may compete with us following your employment with us. The FTC's new rule does not affect other terms and conditions of employment. Exceptions. This shall not apply to a non-compete clause that is entered into by a person pursuant to a sale of a business entity, that person's ownership interest of the business entity, not just like your employees and you sold or something. This does not annul, exempt any person from complying with state regulations, state antitrust or consumer act, etc. And if any part of this is held invalid, it does not invalidate the whole law, as best as they can do that. And there you go. And they make a lot of wild predictions. I don't know how accurate or inaccurate the predictions are. That really wasn't, I'm not really scrutinizing that. Just, you can scrutinize that if you want. I guess they have a graphic, an infographic here. Could I see the infographic, please? Thank you. Okay, banning non-competes, good for workers. An average of 17 to 29,000 more patents. A 2.7% increase in new firm foundation because new businesses will be able to get workers that aren't subject to non-compete clauses. Higher earnings because workers will be mobile and employers will have to pay them to stay. Who's affected? 1 in 5, 20% of workers, or 18%, it says over here, 30 million people. I remember I was subject to a non-compete clause when I worked for Lutron Electronics, I think. And I don't know if they would ever have enforced it, but I definitely did not think I could just go work for a competitor. And I was also a salaried worker, and I didn't think I should be. And there's more to that story. They accused me of stealing from the company, but it was somebody else. They finally caught the person, but I never got an apology. I got demoted, and I never got the position back. And then my lawyer that I hired to handle the whole thing on my end was Don Russo, who I made a video about. He got suspended for 5 years because he was taking people's money and not handling their cases, which is also what he did to my case, but I didn't make a big stink about it because I was a new attorney and I didn't want to make a bad name for myself, and I didn't know what to do. And yeah, so I got really screwed. Not just by a non-compete clause, but by that whole sort of anti-competitive bent that employers put on things. Anyway, so non-competes are banned. Basically, I'm hoping they'll have an official date. I don't know when this actually makes it into the Federal Register. If I do find that date, I will blink it on the screen like the whole time. A little ticker on the bottom of the screen. This goes into effect at this date. But yeah. That's what's going on there. That's really big. That's huge, huge news. Of course, I expect some employer or employer organization, the Chamber of Commerce or something, the private Chamber of Commerce, to sue the FTC and try to invalidate the thing. It could go up to the Supreme Court. It's a big deal. It's a big deal. Every employer in the U.S. uses these things, I think mostly inappropriately. They say only 20% are affected, so I guess maybe not every employee is affected, but every employer that I've ever known has used these clauses. So yeah, it's a good thing that this is gone. Let me know what you think in the comments below.